What are some of the experiences that you've heard that were cause of concerns for shareholders, but that were mitigated or addressed?
So planning is key. And we spent quite a bit of time as a firm internally when the pandemic first happened. It was in the middle of annual meeting season, call it. So typically annual meeting season is April, May, mostly May, frankly, because you wait for the financials to come out. And then it starts again September, October. And so when this shutdown happened, we were just heading into annual meeting season. So we anticipated that this would be an issue. So we started and we sat down and thought about the stuff that can and could come up. The number one concern was this technology question. And that's where we came up with the idea of a pre-meeting and the gathering of information and the dissemination to the shareholders. The second concern was participation. So unlike most meetings, you can't have a Zoom meeting where everyone can talk. So when we run the Zoom annual meetings, I typically run them from my buildings. And I have all of the board members and the property manager and the accountant and whoever else might be presenting sign in a little bit early. I give them all co-host powers so they can mute and unmute themselves, but everybody else is muted, kind of like they are here this evening. And that creates a little bit of a concern for some people because they might feel like they're being stifled. At least that was our concern initially. So we helped to overcome that by explaining it from the beginning. It would be impossible to hold a meeting where you're in an electronic forum and multiple people were talking at the same time. Nothing would ever get done and nobody would ever hear each other. So in smaller buildings, in all buildings, we have people post their questions in the chat. In very large buildings, we ask them to pose the questions in advance, at least if they could, so that we would be prepared with a list and not be running through a chat throughout the meeting. And we still allow them to ask questions in the chat for the most part, and those questions are addressed. And I found that I make a commitment to people early on in the meeting. I promise if you write a question, and as long as there's nothing inappropriate about it, I will ask it. And we haven't had any issues. We haven't had any people complaining about their inability to speak or the stifling, call it, which we were concerned would be an issue early on. In smaller buildings, when we get to the Q&A session towards the end of the meeting, if there's only 10 people on the screen, I will often just ask them to give me a wave and I will unmute them and let them ask their question. There's just a lot less people, but the control, I'm going too fast. The control is maintained by the person who's running the meeting, which is generally myself. Other issues, notices of meeting. Your bylaws still require you to give a notice in person or by mail. So you do still need to do that. All bylaws require that it be at least 10 days before the meeting. That still needs to happen. The notice should specify the location, which in this case would be your Zoom invite. And it should also give specific instructions to shareholders on how to dial in if they're calling by telephone or dial in if they're calling through a smartphone or a computer. Voting is the biggest issue, is how do you handle voting? So I have 3 options that we've employed, and it keeps transparency as high as possible. What it doesn't provide is for anonymity. And it's, as you can imagine, completely impossible to vote anonymously when everything is being done electronically. So for most buildings, we send out in advance of the meeting something called a proxy ballot. And we allow shareholders to vote on that document, which they then, during the meeting, before the meeting, or for a certain period of time after the meeting, they email it to me. And I keep track of all the voting. We also allow shareholders to vote in the chat. And for those that are having a real issue, if they have to, we just have them send in an email, and in the subject of the email, put their name, apartment number, and identify in the body of the email who they're voting for and explain the voting process in advance so they're not voting for too many people. I then follow that up with a thank you so they know that I've received their vote. So there's never a question, did my ballot get lost? Did it happen? Did it not happen? We haven't had any complaints. Early on in anticipation, we thought there would be an issue. We thought people would say, I've always voted anonymously. I don't want to vote this way. People have been exceedingly understanding. We're in a different world. We're making the best that we can out of what we have. And it's been a really good experience, I have to say. I think people are very grateful to be given the opportunity to hear what's happening, to be able to participate in a vote, to have some level of normalcy restored, even if it's not under normal means.
Have you heard of any other for lack of a better term, low technology ways of conducting general meetings and especially elections that might not require a virtual meeting?
So there are buildings, and they're not HDFCs. There are a few buildings that have used SurveyMonkey, which I don't know if that's really low technology.
Mhm,
And I also don't think it's proper. I don't
mhm.
think it doesn't give you the meeting. It doesn't give you the ability for everybody to hear. It's literally just asking people a question and then having them press a button to
Mhm.
answer it. Other buildings, especially smaller buildings, some of them have considered having in-person meetings. If you have a large community room or an outdoor area and you're a 10-unit building or a 15-unit building, and you can accommodate 10 or 15 people while still respecting the distance, the 6-foot distance, and PPE is properly adopted, and you are within the limits that are set by whatever order is in place from the governor at that given time, you could still have an in-person meeting. I don't know too many attorneys or managing agents that are willing to attend these days,
Mhm,
but actually, I don't know any.
mhm.
Let me correct that. But I think, it's being employed in upstate counties where they are very much outdoors and they have large sprawling lands and they can have these meetings and everybody can be 6 feet apart. But I haven't seen it happen in the city. Although a small building could definitely do it.
Mm.
Absolutely. And you can have your lawyer there, on a screen, or anyone else who you want presenting while everyone is physically in attendance.
Do you, s- for a lot of HDFCs, I would imagine that they conduct their general meetings and elections without the assistance of an attorney. Do you recommend that, especially during these times when we have virtual meetings, in order to ensure proper procedures and that meetings are run properly, that they do it in conjunction with an attorney?
So obviously, I'm always going to tell you if your attorney is supervising what's happening, you have someone else to blame if anything goes wrong. And that's where you get your guidance. Some HDFCs, believe it or not, have been using UHAB, and UHAB has a electronic platform also. It's not Zoom, it's GoToMeeting or some other program like Zoom, where they're running the meetings, and as they would if they were running your normal annual meeting. I would suggest strongly making sure you have someone who knows what they're doing, supervising and monitoring. If not, if you have a hotly contested election, you might have other issues that come up after the fact. So with voting, with tabulating votes, was the notice sent properly? Was attendance taken properly? One of the issues that could come up is, especially if you're not face to face, is how do I know the person on the other end of the line is who they say they are? And
Mm.
it could be an issue. I haven't had any meetings or votes end up being contested thus far, which normally they would have been by now. I think in normal times, even with the in-person meetings where you have battles for power, You get lots of contested elections where people are bickering over the votes, especially where things are very close. That hasn't happened to me yet, at least not since April. And I think it's just a factor of, people being grateful for the little bit of normalcy that they're getting.
And what is exactly the interaction that a shareholder can have with their uh, board of directors during a general meeting and elections that's acceptable, especially as they sort of at these meetings they hand out financials and there may be some questions. Is using the Zoom system still the preferred way of doing that, or and I guess this is going to lead to our next question, is during the course of a normal year, when there are sort of concerns um, for which a shareholder might want to communicate with their board members and or management, especially as work is happening throughout the building and there are certain communications that have to happen. Um, what is the preferred way for that communication to happen during the time of COVID?
So, I don't know that preferred is really an answer that I can give you. Let me start with the first part of the question. Well, first of all, communication. I think communication is more important now than it was before. Not that it's not always important, but I think in a time of unknown and uncertainty and where people are uncomfortable knocking on each other's doors, the communication that's coming from the buildings, whether it's management or the board directly or the super or whoever it might be, is that much more important. Communication can continue to be in writing. The Postal Service is functioning. You can put a letter in an envelope just like you did before. I have really encouraged buildings to take this opportunity to gather email addresses, their shareholders. It really makes it easy when a board can send an email to everyone and let them know what's happening. It enables the communication process to be much more effective. In buildings where that's difficult, I don't discourage emails. You can still email, but you can also put a letter under the door, put a letter in the mail, make a phone call. A lot of HDFCs are not huge buildings. And if you're a 20 unit building, call it, and you have 2 shareholders that are never going to look at their email, perhaps you can make a phone call and say, hey, I just want to let you know we sent you an email, or we sent something in the mail, please take a look at it. It's that extra little bit of attention coming from the boards is very appreciated, especially by people who aren't technologically savvy and are probably having much harder time during this time because of that. As far as meetings go, Zoom's easy. You can share screen. So boards are still going through financials. I'm having CPAs attending the meetings. The financials are posted on the screen so people can take a look at them. Obviously, they're mailed out in advance because you are required to send them to your shareholders, but they're still reviewed together on the screen, which is more than what happens sometimes in buildings during a meeting because you don't have that ability to hold something up large enough for everyone to see at the same time. Screen share is a joy because you can share that information with shareholders. You can share lots of things, forms for documents, email addresses, notices that have been posted. Financial statements and construction issues have been the largest as far as sharing thus far. But the screen share option really does make it much easier to function.
With respect to activity that happens in and around the building, and you just right now mentioned constructions, and I guess that for many HDFC, this activity is continuing. What are some of the concerns that should be in the mind of not only HDFC shareholders, but their board of directors with respect to compliance, social distance compliance, and PPE compliance when activity in the building happens, whether that be construction or renovation, people moving in and out, sort of from a safety perspective?
So very early on, HDFCs were the exception to the freeze on construction because you're a not-for-profit. Although construction was stalled in the city, HDFCs were able to continue. Not that many did, but you were able to do so. You qualified under the exception. So early on, we created some documents for our boards to use, not just for the big contractor coming in to do a $200,000 project, but for the exterminator, for the plumber, for the electrician, frankly, for the staff. If you have a super or a porter, as they're making their way around the building, making it clear to them what the rules are and what the expectations are. And these documents were called waivers, but they not only acted to protect the building against claims by these individuals that they contracted COVID in the building, but also making clear rules for the individual's behavior while they're in the building. The checking of temperature for staff, the quarantine requirements, the contact requirements. There are very specific rules for construction on what they will need to do with respect to tools and having multiple people working in the same area, the use of personal protective equipment, which we call PPE, like masks and gloves, and requiring the contractors to make those available. Some contractors have required, and I'll use this example, it's the exterminator who has to walk through everyone's apartment. They've required the shareholders to sign a document stating that they haven't been in contact with anyone or experienced any symptoms before they will enter the apartment. So it does go both ways. A lot of people are looking to protect themselves, just like the building wants to protect itself. I've encouraged boards to pass house rules requiring the use of personal protective equipment while in the common areas of the building. It should be second nature, right? I mean, it's a governmental order at this point. The governor has ordered the use of masks basically at all times. The board shouldn't have to pass a house rule. It should be enough that the governor required it. But you would be surprised how in some circumstances the house rule did more than the governor's order did. And it has been useful. That should be disseminated. It should be posted. People should be reminded. If the same person is repeatedly in common areas without proper protective equipment, a formal notice should be sent to that person. It is A, violation of law, and B, highly disrespectful to everyone, especially the elderly and those with compromised systems, who many of which are just afraid to leave their homes. Yeah.
Is the contact tracing requirements that you find commonly among restaurants and social gatherings, low impact social gatherings, is that a requirement for HDFCs with respect to visitors, such as exterminators or contractors, or even city agency inspectors that come in from time to time?
I don't understand the question. The contract.
Is that a requirement? In other words, contact tracing requirements requires that one, you take a temperature, two, you take their name and you get their contact information, and you keep a log you keep a log of their visit, so that if there's an outbreak, there can be tracing of and information passed along to people about or to the Department of Health, I guess, who requires it in restaurants. That if there's an outbreak, they can trace the infection.
Yes, you are supposed to be keeping a log, a sign-in sheet of who comes and when. This was an order that came in early on from the governor, and it's difficult for buildings that don't have a ton of staff. So what we've suggested is that you put it kind of by the front door, and you ask your people to sign in and out as they come and go. And yes, you should be doing it. It's part of what you're supposed to be doing in operating the building. In fact, you're supposed to have a safety plan in place. Early on, the state provided a link on their website for what a safety plan should look like or could look like and what it should include. But every business, including a co-op, because you're a business, is supposed to have a safety plan in place. And part of that safety plan is maintaining a log of that nature.
Need to understand. Well, that's interesting. There are many challenges, obviously, and working through general meetings and elections are just part of it. Certainly, managing and mitigating visitors to a building is one. What are some of the concerns, or perhaps better, what are some of the resources available to HDFCs, either through governmental agencies or any other source that HDFCs should probably avail themselves of, especially during this time of COVID, and especially with respect to HDFCs that may have maybe as many tenants as they do shareholders, or derive their income in equal portion or in equal amounts or in large amount from commercial tenants, for which I know some HDFCs do have commercial tenants, certainly mine does. What are some of the resources available to, and what is should be the stance of the board and shareholders in helping tenants and helping commercial, especially if they're commercial tenants and residential tenants, during this time of COVID? Obviously, non-payment of rent, whether it be residential or commercial, affects the income of the building. So what are some of the things that an HDFC can do to help in those instances on a residential and commercial side when we talk about rentals?
So the issue is, if someone's not paying, you can't do anything about it. That's at the very nature of most of the governor's orders. And basically the landlord-tenant court and process is frozen at the moment. While they say they're taking cases, anybody who's been affected by COVID, the cases are being pushed off to May. And if you're not, to March. But even then, nothing's really happening with them. So it's the era of cooperation, as I call it. I've never seen people be as cooperative as they have been at this time, especially with commercial tenants. And I have a few HDFCs and non-HDFC buildings with commercial tenants that are struggling and not paying, or paying a lower amount. One of the main things that we've done with all of these buildings is aggressively pursue conversations with the tenants and come up with a plan on what they can pay and how to either forgive the rest or recoup it later on. In my opinion, a tenant paying a quarter of their rent is better than an empty space, or a tenant who's not paying at all. If you end up with empty space when things begin to resume, you will be one of millions of storefronts looking for tenants, where there will be a very small pool of available tenants. So there is a huge value to having a tenant that, even if they're operating at a percentage of their business, when things restore, they will be able to regain operation in an existing business and continue to pay their rent. With respect to residential tenants, it gets more complicated. You're not allowed to charge late fees. You can't pursue collection. There are rent assistance programs that are available, but there's some income that needs to be established, and they're not the easiest to navigate. I suggest calling your local elected officials if you want to take advantage, if you have tenants who want to take advantage of those programs, and ask for assistance, because they have the ability to assist you in processing those requests. They have the inside track to the people in the know on how to do it and how to get it. As far as shareholders not paying, there is no assistance available. And the biggest problem and my biggest fear are that buildings that are barely holding on, were barely holding on to begin with, in the ability to pay their bills, are now going to face some collection issues. And at some point, those collection issues might put them back into trouble. So as a board and as a manager, if you're a manager, you have to keep a very close eye on the money coming in and the dwindling balances in your accounts. Because if you're coming close to a problem, when you don't pay your real estate taxes or you don't pay your water bill, you are going to have a much bigger problem down the line and might be forced back into a regulatory agreement, long-term payment plans with interest and penalties. I have one building on the Upper West Side that is very heavily dependent on their commercial income. They have, I think, 18 units or 16 units and 3 commercial spaces. And they are very, very dependent. 2 of them are not paying at all. One is paying a percentage, and we've negotiated to get the other 2 paying something, but they just don't have the ability to pay full value, and there's nothing we can do about it if they don't. So the building has had to pass a maintenance increase in order to make sure that they can pay their bills on a monthly basis. Nobody's happy about it, but it's the business, and you have no choice.
Mhm.
The tenancy is not a tenancy. You're an owner in control.
What do the coalition has taken the opportunity to make a list of resources, not only to shareholders and their boards, but also to tenants
Right.
that we know are available through the various city agencies. And I just want to share my screen for just a second.
Before I forget the most important one.
I'm going to segue into that.
Okay.
You're talking about Triple P, right?
Yes.
Yeah, and I'll segue into that. But I want to first share my screen and see if we can go to, I'm going to share my screen now. Can everybody see what I see?
Yes.
Okay, fantastic. You're on the landing page of our wonderful HDFC Coalition website, and you can see all our fellow shareholders taking on the cause when against regulating HDFCs coercively, a battle for which we won. But if you scroll down here, you'll see the announcement to today's webinar, and then you see our lovely presenter there, Emma Lupu. And even scrolling down further, we also have right here a resource list in English and in Spanish. And if you click on, you'll get this document, which you can download. And it has various helpful information for HDFCs with respect to the PP program, which Emma will talk about more thoroughly, as well as other links to different city agencies for which you can communicate and express your concerns and perhaps get some assistance. And there's a legal assistance section. Again, this is for both shareholders and their tenants, the shareholder tenants, the board tenants, the building tenants. And you will also at the very bottom see there a bill that's going through the state Senate with regard to providing rental assistance. And again, the very same list here in Spanish. So I'm going to stop sharing and get back to Emma. And I guess one of the largest resources and perhaps maybe an untapped resources for HDFCs is the federal PPP program. And if you can talk about the PP program and how it can really help HDFCs and maybe help them mitigate the problems with the loss of revenue they may be experiencing from rentals.
So I don't know that it'll go as far as overcoming a massive loss in revenue, but earlier this year, the federal government made available something called a PPP, which stands for Paycheck Protection Program. It's a loan, and it was made available to all businesses under a certain size, and then forgiven, assuming that you could prove that you were using it for a proper purpose. At the time, there was a question on whether or not co-ops qualified, and it was extremely unclear. So the guidance was that they would not qualify. The new Paycheck Protection Program, which was just passed less than a month ago, has new funds and is specifically available to co-ops, as well as lots of other businesses. You can apply through your local bank, whoever you bank with. If you have a mortgage, some HDFCs do have mortgages from private lenders. You can probably get it from them as well. The loan, as it starts out, will eventually be forgiven if you can prove that you used it for appropriate purposes. And a lot of that is centered around paychecks to your staff or to employees. And in some cases, you might be able to use it for rent or maybe real estate taxes. You have to speak with your bank to see what the guidelines are for forgiveness on your particular loan. But even if it doesn't get forgiven, it carries a super low interest rate, which makes it desirable if that's all that you have available to you. Either way, I encourage every building to take advantage of whatever they can qualify for that will ultimately be forgiven. It's free money. And even if it's only a couple of $1,000s, it's a couple of $1,000s more than nothing. So I encourage you. I know there are many businesses that took these loans out back in April, May, June, earlier this year when the first round was available that really didn't need them. And it's a shame because the buildings that need them are the ones that should get them first.
So other than helping pay for employees of the building, some of it can be used to pay for operating costs, just not the loss of revenue. I mean, I think they have to prove that they had loss of revenue.
No, they don't. So there is a requirement in the new law that you have to prove a loss of revenue, but that is only for second-time applicants. So anyone who got the PPP earlier this year and is applying for a second round has to show at least 25% loss of revenue in any one quarter over the prior year. So if it was second quarter or third quarter 2020, you would have to compare that to third quarter 2019 and be able to show at least a 25% loss of revenue in order to qualify for the forgiveness. If you are a first-time applicant, you do not need to establish that. You just need to be able to sign a certification saying that you've been negatively affected by the pandemic.
But other than paying for employees, and that may not represent a large operating cost.
Yes.
What are the other operating costs that do qualify and can be written off through the second round of PPP, whether you're first or second time applicant?
I think you need to speak. The banks they're getting guidelines from the SBA on specifically what will be approved long term on this. Just understand it's called PPP. Paycheck Protection Program.
Although there are other qualifying costs that could be covered under that.
There are some. I don't know all of the specifics as to particularly financially which ones they're allowing on this round. On the prior round, it was rent and some limited operating expenses, but at least 75% had to be used for
payroll.
Yeah.
Okay.
So I believe it is similar this time. I think we can put the guidelines up on the website for people to use, but I encourage them to speak with their local lenders to get absolute clarity on what's been permitted under. They're constantly issuing opinions on what the guidelines are and should be.
Great, wonderful. Well, I see that we have a lot of questions in the Q&A, and I think this is about time for me to turn over the meeting to our Q&A queen, April Tyler. April, are you there?
I am here.
Fantastic. I'm going to turn the meeting over to you so that you can manage some of the many questions I see here for Emma and perhaps for the coalition.
Okay, so I again thank everyone for attending, and Michael, would you just please say in Spanish the interpretation information again in case someone hasn't been able to access that?
Sí, claro que sí. Si quieren escuchar la discusión en español, por favor, oprime el botón que está abajo que dice interpretation. Es como un icono de un globo. quede por la derecha. Y entonces, si imprima eso, te va a llegar a un cuarto donde se puede escuchar la reunión en español.
Thank you. Gracias. So first, Emma, the first issue that I wanted to cover that has come up from a few people is the documentation that they would need. One is some buildings or some officers or boards of directors or even management companies are refusing to hold meetings and saying that they can't hold meetings because they can't do it in person.
Mhm.
And spoke to the fact that there is the ability to hold virtual meetings and also to do virtual voting. So two things. One is, can you provide links to that documentation so that shareholders can refer the management companies or the boards of directors to that so that they can hold the meetings that they're supposed to hold? And then secondly is just for everyone's information, the information that we have about PPP and where you can get the details of that, we'll post on the website for everyone to see. And we'll do that by tomorrow.
So 2 parts on that first question,
Mhm.
April. Can you and must you are 2 different issues. There is no order or law that says you have to hold a virtual meeting. Your bylaws provide that an annual meeting has to happen within generally the law says 13 months of the prior annual meeting. If boards fail to call an annual meeting, a shareholder's right is to demand the calling of an annual or demand the calling of an election. And if the board continues to refuse to do so, the only thing a board can do most of the time, with very few exceptions, because there are some bylaws that have other provisions, is to go into court to ask that the court order that a meeting be called. Will a judge order a meeting where no in-person meetings can be held? Will a judge penalize a board for failing to call a meeting in the middle of a pandemic? I don't think the answer to that question is a yes. I think it is a good business practice for boards to call the meetings. I think they absolutely should be. I think the ease at which these meetings are held virtually makes it really odd for the boards that refuse to do it. But I don't think that you're going to get in front of a judge that's going to penalize a board for having concerns about having a virtual meeting, maybe claiming that they're not technologically savvy or their shareholders aren't or the like. So I can't give you a link to anything that's going to say they have to. What I will say is your bylaws require meetings to be held within 13 months for annual meetings. It's 12 months, but the law gives them a 30-day leeway. So it's really 13 months. The governor's executive order has abolished the requirement for in-person meetings for all not-for-profit corporations. Just a little caveat. Somebody asked me, well, what about HDFCs that are governed by the BCL? They're still not-for-profits. Not-for-profit is a tax status. It's not an incorporation status. So all HDFCs are governed by the private housing finance law. Some are business corporation HDFCs, others are under the not-for-profit law. Either way, you all have not-for-profit status on your filing on your taxes. So there is also an amendment to section 602 of the BCL that was passed before the pandemic, which was to address some questions that lots of buildings had in the ever-changing world of technology. Lots of buildings wanted to give individuals the ability to attend shareholder meetings virtually, but there was nothing that said they could do that. Not should, but could. So the BCL, the Business Corporation Law, section 602, was amended to allow shareholders to attend a meeting virtually, as long as they could hear and be heard. So that is your legal basis. And I'll be happy to provide you links to those statutes, April, so you can post them on the HDFC's website for easy access.
Okay, thank you so much. Just to further that question. So short of going to a judge and the courts that are backed up with other matters, what can shareholders do if a board of directors is indefinitely delaying an election? And their excuse being that they can't hold an in-person election? Would the shareholders be able to somehow take matters into their own hands?
That would depend on what your bylaws say.
Mhm.
I would say 99%, 95% of the bylaws, the answer is not much. You can reach out to HPD, and there is a link on the coalition's website for contact information for Louis Sagaro from HPD, and make them aware of what's going on. If you're being supervised in any manner and operating with the assistance of a not-for-profit like you have, or NHC, you can reach out to them and exert pressure in that way. And I say almost no, and if you would have asked me this question a few weeks ago, I would have said never. But recently, one of my newer buildings has a provision in their bylaws that allows shareholders to actually call a meeting. This is very unusual. It is not the norm, and it is not in a lot of bylaws. So I don't want to ever give anyone false hope and say you can do it. If it's in your bylaws, and in this particular building, shareholders who own more than 10% of the shares, so basically a 20-unit building, that means 2 people, can actually call a shareholder meeting. It's not an annual meeting, right? An annual meeting gets called by the board.
Right.
But they can call a special shareholder meeting. And in those situations, you have to be careful because your notice has to say the right thing. So your notice has to say that the meeting is being held to remove the current board and elect a new one. So the first order of business at this meeting would be to vote to remove the current board. And the second order of business, if the first vote passes, would be to elect a new board. Why is that different? The difference is the only real purpose at an annual meeting is to elect directors. Their term ends by definition under the bylaws when the next annual meeting happens. And if the board delays, their term technically continues until the meeting happens. I've never seen bylaws that allow shareholders to call an annual meeting. And I've seen a lot of bylaws. So I'm going to confidently say you can't do it. But you might be able to call a special meeting to remove the board and elect a new one. So while it's not an annual, it's not a straight election, it does the same thing effectively.
Okay, thanks. And I would, if anyone is interested in pursuing that route, very carefully read your bylaws, because there are specific instructions regarding special meetings and how they're conducted, how they're advertised, the notice requirements, and how the meeting itself is conducted.
Yes.
So if this is your last resort, please very carefully read your bylaws and or get assistance from counsel. Okay, so talking about meetings, one of the questions was how would the board, the shareholders, or whoever, if it's an outside entity, how would they ensure anonymity during elections?
So that was part of my speech earlier. It's almost impossible. And I know a lot of HDFCs want the anonymous voting, which they're accustomed to. But it would be impossible to allow anonymous voting during a meeting, while at the same time ensure that the people voting are shareholders. So if you're voting by email, it's impossible. Theoretically, the only possible way to do it would be to hand out paper ballots in advance of the meeting and put a box in your lobby. Maybe put a code on each ballot to make sure that it's going to the apartment it's supposed to go to, and then have them fill out the ballots, drop it into the box, and count it at some point later on. instead of voting electronically, they'd be voting by paper. The problem with that is you're mailing a ballot to an apartment. Somebody's getting it. It's not being signed. The person's not physically in the room and they weren't physically handed the ballot. So you don't know if the person who's filling out and putting the ballot in the box is an actual shareholder. In my buildings where we rely heavily on where we want anonymity in voting, shareholders come in a room, they sign in, they're identified, and they're handed a ballot. Or they're handed a slip of paper, which is later replaced by a ballot. So you know that the individual that's being handed the ballot is the shareholder. In the worlds of the pandemic, that's impossible to do unless you're having an in-person meeting. The closest you're going to come would be putting a ballot box in the lobby or somewhere in the building and having them deposit their ballots in there and hope that the person who's allowed to vote is really the person that voted and not their daughter or their roommate or someone else who intercepted the mail.
Okay. Well, yeah, what our building does is we do double envelopes. So you sign the exterior envelope and the interior envelope is blank. That doesn't necessarily negate someone who lives in the apartment from casting an invalid ballot, but that's the closest we've come to protecting anonymity and ensuring that the ballot is from the particular person.
That having been said though, April, if you have a third party running the election and the votes are going directly to the third party, nobody other than the third party will ever see them, knowing who lodged what votes, let's call it.
Correct.
So if that's something that's of concern, trusting your lawyer, trusting some other person to maintain anonymity is possible, A. And B, there's a company called Honest Ballot Association. It doesn't come at a cheap price, but they run these elections differently than I do, with much more electronics and less in-person stuff. But they don't ever release the results or who votes how. And that's how they make a business on keeping that anonymity as is. Unless there's a court order, they're not releasing it.
Okay, so thank you. I'm going to go to some of the questions that relate to residency and arrears, both commercial and residential. Let's do residential first. One of the questions was, if someone has moved out of their apartment because of COVID and is living someplace else, and as the pandemic draws on, they are technically in violation of the primary residency law, correct? Or has that been waived? And is there any recourse should the board or the other shareholders want recourse related to that? And then another question was the eviction moratorium, which was extended now till May. Does that include arrears, or would the arrears going back to February or March when the pandemic started, would those be then due and owable once the moratorium has ended?
I'll start with the second one first. The answer is there is no law that waives arrears. It just disables your ability to collect at the moment. So the moratorium says nobody can be evicted for not having paid. It's more than just not evicted. It's literally, if you were to file a case today against someone, it would not be returnable until May. But it doesn't waive the arrears. There's no actual waiver. They're still owed. They still need to be paid at some point. Will there be a law later on that calls them waived? I don't know. I have to tell you, I can't see how such a law could be passed, because there's a symbiotic dependency between those that pay to the landlords, or the co-ops in this case, and the co-ops who pay to the city and the state. Real estate taxes, water, gas, electric bills that need to be paid without rent or use and occupancy or maintenance can't be paid. You don't have, I would venture to guess that most buildings, not just the ones on this call, don't have tens or hundreds of thousands of dollars sitting around to cover for money that's not being paid. So it's just a delay in collection. Obviously, it's going to be that much more difficult to collect once 12 months or 13 or 14 months of rent has accrued. I will say that for commercial tenancies, it is still just a delay, but there was an amendment passed to the general obligations law by the city council, making personal guarantees on commercial leases ineffective and inoperable during the pandemic. So what does that mean? That means corporation ABC rented your store. The corporation has nothing other than the money that comes in from the sales in the store, but the owner personally guaranteed the lease. So if the corporation decides to take off and never pay you, the owner still owes you the money and has to pay it. It gives you another person to seek collection from, but that was basically made inoperable during the pandemic with respect to the personal guarantee element only. So business continues, the business still owes you the money. And the second question was primary residence. So most HDFC proprietary leases require primary residence or occupancy for at least 183 days a year. Many people think that in order for an apartment to be your primary residence, you have to sleep there for 183 days a year, and that's not accurate. Many people have left their homes and still maintain that home as their primary residence, but they've temporarily relocated, and temporary can be a year or two. It doesn't have to be a month or two. For various reasons. I have board members in some of my HDFCs who have moved to other states because they're nurses and they're caring for COVID patients, offering assistance where it's most needed. Healthcare aides who have done the same. They're still maintaining their primary residence at the apartment. Their taxes are still being paid, and the address is still the apartment on the taxes. All of their business and personal communication is coming to the apartment. Their belongings remain there. They haven't vacated and abandoned. They've merely relocated for a period of time. That, in my view, is permissible. I think that if an HDFC will want to make a claim against a shareholder for non-primary residence at some point in the future, claiming that the fact that they vacated during the pandemic meant that they were violating their proprietary lease, I don't think you'll be successful. I don't think there's a judge in the city of New York that's going to penalize or throw out a shareholder or allow you to terminate their leases for not having remained in their apartment while the pandemic was happening. In fact, I will say the mass exodus, as I call it, is not as prevalent in most HDFCs as it has been in our non-HDFC buildings, but it's happened. There are people who have relocated, the husband and wife with 3 kids that live in a 2 or even a 3-bedroom, realize that it's very difficult, especially people with children, to navigate the city when you're locked in an apartment. So a lot of people have gone, many came back, may have gone again, but during the summer, many came back. And I don't see there being a claim for non-primary residence. Could you make it? Sure. Do I think it's wise? No. Do I think it will be successful? No.
Okay, let's go to the enforcement of 2 questions. One, the enforcement of mask wearing, and what recourse do shareholders themselves or boards have if people, even if signs are posted, sanitizers available, etc. What recourse do they have? We're not like the MTA where we can give out tickets. What recourse do we have?
So the easy answer to that is if you've amended your house rules and added it as a house rule and someone is continuously violating it, you can serve them with a formal notification that they are violating their proprietary lease by failing to comply with the house rules and with the law. that formal notice generally comes from your lawyer, which means there's a legal fee attached to it, which is billed back to the shareholder. If they continue to violate, that's called a notice of default or a notice to cure, whatever you choose to call it. If they continue to violate, you can then terminate their proprietary lease, and you can go as far as commence an eviction proceeding if the conditions continue. So in general, anytime a shareholder or a resident violates a rule, your only real remedy is to place them in defaults of the proprietary lease. But I have some buildings that have passed fines for violations of those types of rules. Those fines are only legally enforceable if they're passed as amendments to the proprietary lease, which always requires a shareholder vote, and generally a super majority, in some instances 75% of all shareholders. So your best, absolute best method would be if you were able to pass a fining policy. It's a lot less expensive than having to call your lawyer to serve notices, and nobody wants to pay a fine. So sometimes it's a lot easier to throw a mask on your face than to pay a $200 fine.
April, I have a quick question and a follow-up to wearing of masks. When somebody enters the apartment, of course, they're wearing masks, we would hope. What are the rules for the owner and the occupants of the apartment? I would imagine it's good practice to wear a mask, but what are the legal requirements?
The law says that in public spaces or common areas, you don't have the ability to enforce as a co-op board what goes on inside people's apartments. If they choose to wear masks around one another or not, that's their choice. The rules are constantly changing. The CDC and the state are putting out new guidelines all the time. If one person tests positive, they're supposed to be isolated, or if they're showing symptoms and pending a test result, they're supposed to be isolated. Everyone's supposed to wear a mask around each other, but the co-op doesn't have the power to enforce what goes on inside the apartment. The enforcement and the regulations concern the common areas.
Right. I guess the question, just to sort of the number two would be, if a plumber comes in and we're not wearing a mask, and he asserts at some point, I, contracted COVID in Tina's apartment. I mean, does he have any legal standing?
It would, as a practical matter, it would be virtually impossible for a plumber to prove where they contracted COVID, number one. Number two, there are rules that require individuals to wear PPE equipment in their apartments if they want services from outside. So your super should not be going into anyone's apartment unless they're wearing proper protective equipment. If he shows up and they don't have it on, he should be instructed not to enter. If he's in the apartment and the individuals are walking around without it on, he should be instructed to leave. And the same goes to anybody that's providing a service to the building. That is you enforcing not the rule of the common areas, but the rules under which you'll provide them a service. You're not going to allow an outsider at your bequest to enter the apartment and have any interaction and close contact with anyone unless the proper protective equipment is being utilized.
Just as a follow-up, what is the onus for the owner of the apartment in terms of their obligation to the vendor?
You mean what liability they would have to a vendor if they weren't?
Right. I mean, for practical purposes, we should be wearing, a mask when the plumber comes, but is there an obligation?
Well, yeah, if you're around someone who is not part of your immediate family or your group that you live with, you're supposed to wear a mask if you're within 6 feet of them. If you can't properly socially distance, yes, you're supposed to wear a mask. And I guess theoretically, if they were to contract COVID from you and be able to prove it somehow, let's say you're the only person that they were around it's very difficult. You understand the difficulty, right?
Yeah.
So that's why I say, yes, you're supposed to have it on. But the only real remedy, what should be happening if you don't follow, is that the service should stop. You should exit, the individual should exit the apartment, and a letter should go to the shareholder that says, we were not able to provide you such and such service because you refused to comply with PPE requirements. And you know, I don't foresee that would go over very well if they were ever to try to make a claim. I think that the whole PPE world and the requirements that are involved are very much supported by both the law, the politicians, the judges. There's no question about it.
And I think I would just add, Emma and Tina, that if you yourself or someone in your household has COVID, or was exposed to someone who has COVID, they should do all that they can to distance themselves in your household. If they have COVID, they should be isolated, and you should wear masks anyway. And if they know when you're getting services, then it would behoove you to wear masks when someone is in your apartment providing a service. And as Emma said, it would be very difficult for someone to prove that is exactly where they got it. They contracted it if they contract it later on, but it would make sense and, you know, is the conscionable thing to do, to wear a mask when people are coming into your apartments to provide services. The next question is, what requirement does a shareholder, and I know the answer, but I'm going to ask the attorney, what requirement does a shareholder or the board have to inform other members of the co-op that they have COVID-19?
So privacy laws prohibit shareholders, managers, supers, whatever, from releasing the identity of somebody who has COVID. This is an issue that came up very early on, and we did a lot of soul searching about it, and a lot of conversations happened. And the norm has been, and what I think is the right way to handle this is, if you have a confirmed positive in your building, you can send a letter, a notice out to your shareholders, letting them know that there was a confirmed positive and that they should take caution in the common areas. In some buildings, there are, I know a lot of HDFCs don't have elevators, but where there are elevators, they have made the one person at a time rule, where if you call the elevator button and it opens and someone's there, wait for the next one, wait for it to come back up so that you don't have multiple people. And most of these elevators, it's impossible to social distance. I don't know too many elevators where there's enough room for people to be 6 feet apart. So you do notify your shareholders that there was a confirmed positive. You do not tell them who it was. And this comes up a lot in the world of staff. So I've had a lot of buildings where supers or porters or some other staff member has come up with a confirmed positive, and the board wants to tell the building that the super has COVID. You can't, not unless he says you can. There's a privacy concern. You cannot release that information. If there was a direct contact, so let's say your super went into apartment 1A yesterday and spent an hour in there doing something with the shareholder at home, now that's a direct contact. It has to be reported to the Department of Health. And in that situation, you can tell that individual, you are a direct contact of a known positive, but we can't tell you who it was. You cannot release the identity of someone under any circumstances without their approval. Early on, we had instances where, you know, we feel bad for this gentleman. He's elderly. He could really use our help. If we could just tell people that he tested positive, I know people will help him. I know that the neighbors will go and get his groceries for him, pick up his prescriptions and drop them off for him. Even if you're doing it out of the best intentions, you can't do it without their approval. April?
Yeah, okay.
Okay.
Sorry. So let's go to, actually, can you just reiterate? Someone asked a question about late fees during COVID. If someone is in arrears, it's clear that you cannot pursue eviction, but are late fees that would normally be charged, are those still accumulated?
They were
And then-
specifically prohibited by
Okay.
one of the very first executive orders.
Thanks for that clarification. Someone had a question there. They're intending to sell their shares, and the buyer has a full-time caretaker who wants to live in the unit. Are they able to live in the unit? Because with the rent stabilization, you're allowed to have a non-family member live in the unit. Does that apply also with co-ops?
Yes, the New York state law has a law called the roommate law. I'll spare you the exact quote to the location, because if you Googled roommate law in New York, it would come right up. And the roommate law says that no landlord can prohibit anyone from having one roommate.
Okay. I'm just looking to see how I can group them. So a shareholder just moved. Can the board take over the apartment to rent it or sell it? The answer is no. There's a specific procedure. Would you quickly outline that?
The answer is no. And the specific procedure would be you have to get legal possession of the apartment. And under your proprietary lease, you have to terminate the lease. So if the individual is in arrears and they're no longer living there, then you contact your attorney. The first step would be to serve a default notice on the individual for being in arrears. The second step would be to terminate their lease. And the third step would be to sell the apartment at auction. None of the current executive orders in place prohibit you from selling the apartment at auction. So just understand that the government is trying to protect against people being thrown out in the streets where they have nowhere to go in the middle of a pandemic. They are not trying to protect people who don't live in their apartments and have vacated from not paying maintenance and profiteering off of the circumstances. So under the current executive orders as they stand, you could, if a shareholder has permanently vacated an apartment, they're not living there any longer, and they are not paying their maintenance, you can pursue the default process under your lease and then sell the apartment at auction. And there's a particular process that your attorney would undergo in order to do that. If there are, was that the whole question? No, I forgot. I'm sorry, April.
Yeah, if the procedure to prove that the co-op owns an apartment that someone has just vacated,
So
they have to go through a court proceeding in order to.
I think every HDFC I represent came to me with one of these. And I know that sounds crazy, but I'm being serious. I can't tell you how many HDFCs come to me and they said, I own this apartment. And my first question is, so how did you come to own the apartment? And the response that I get is, well, so-and-so left 20 years ago, and we've been renting it out ever since. Well, you don't own the apartment if you haven't done the process properly. So the proprietary lease is a contract. In order to terminate a contract, you have to go through a procedure, and the procedure is outlined in the proprietary lease. And then you have to dissolve the shares. So once you've gone through the proper termination procedure under the proprietary lease, the next step would be to sell the shares. I have circumstances where the individual was evicted 20 years ago, but I never did anything else. Well, what you should have done is sold the apartment at auction after the shareholder was evicted. But they didn't do that. Instead, they just re-rented the apartment out. And I will tell you, in the circumstances like that, you actually re-rent it on account of the individual who you evicted, as terrible as that sounds. Mm-hmm. So it is generally most HDFCs that are going to qualified counsel for the first time have one or more of these circumstances that need to be resolved. And I'm going to encourage you, resolve them, please, because they can become real nightmares later on. I'm living a nightmare right now for one of my buildings that did this 25 years ago. And the individual is deceased. And now the state has stepped in and they want to be made whole, and they want all the rent that was collected. And it's a mess. So don't get stuck in that mess. Do it correctly.
So I'm going to ask the last question about potential elections. So if the board is not calling elections and there isn't a third party who's running elections virtually, the shareholders decide that they're going to go the special meeting route. How, if they do not have access to rent rolls or building financials, are they able to substantiate that people who attend the special meeting are eligible to cast a vote to dissolve the board?
So two things. First of all, I'm going to caution you because the beginning of that statement discusses the special meeting route. And I'm going to remind you, there are very few buildings that have that ability. So be very cautious. Most bylaws say the board must call a special meeting when directed by the shareholders. But that doesn't mean that if they don't do it, you can. So if you don't have specific language that allows you to actually call the meeting, you can't do it. Assuming you do have it, you can make a demand of your management company or your board for a shareholder list. You can also make a demand for a list of qualified shareholders. Most HDFCs, if you're in arrears for more than 2 months, you can't vote. Or if you're not in good standing in some HDFCs, you can't vote. So if they refuse to provide it, well, then you do what you can with what you have. And at some point, someone will challenge the election. And at that point, the count will happen based on the real information. I will say my boards that I represent, when they get a demand like this, I encourage them to follow through with the meeting and to participate in the process rather than hindering it. You know, I know that it's the end all be all to remain on your board. And it is for a lot of people. But at the end of the day, if you can't win an election, you're fighting a battle you're eventually going to lose. So focus on speaking with your shareholders, explaining why you should be there and what you have to offer them, rather than muscling your way into remaining on the board, which is common. It happens, unfortunately. The democratic process will eventually win out. So if the vote is not in your favor and the shareholders end up being in arrears, it'll have to be addressed. How? Not without court involvement. So if nobody's going to cooperate, if this is a building that's doesn't have a management company and the board's not being cooperative, calling the meeting, winning the meeting is still not going to get you control of your building, because if they're not being cooperative, they're not going to relinquish control anyway. So you'll end up in front of a judge at some point. But hopefully that's not the case. Most of the time you have, and the management companies, to the extent that they're involved, will provide that information in advance of the meeting.
Okay. So Glory Kirsten has submitted something in the Q&A stating that, and I've actually seen this too, that most of the bylaws that I've read allow for shareholders to call a special meeting with proper notification and the required percentage.
It's buildings converted during a particular period. You know,
Right.
HPD changed the bylaws drastically. So there's like a 2-year period of conversion. I will tell you, most of the early HDFCs do not have those provisions. I've never seen it actually in an early 80s HDFC. At some point, HPD changed the form they were using and included that paragraph in there, and then took it out again in the later form.
Okay. Okay, thanks for that information. So what about practices during COVID for subletting an apartment? Are there any particular provisions regarding that? And then just let me, as a preview, there are many questions about financial aspects, the PPP, and resources that are not available for HDFC. So we're going to talk about that a little bit.
So what was the first question? I got stuck.
Subletting an apartment.
Subletting. So subletting is subject to board approval. Lots of buildings have relaxed subletting restrictions. Again, subletting is another one of these conversations that's very dependent on what your bylaws say and what your proprietary lease says. Some buildings limit subletting to people who qualify. income wise. Some buildings limit what you can charge an individual. You have to look at your governing documents on the subletting issue. What I will say is boards have been more forgiving on sublet restrictions where they might normally just not allow subletting, period. I've had lots of boards rethink that, mostly because they want their maintenance to get paid. So if an individual was forced to relocate, perhaps lost their job, perhaps needs to take on a subtenant in order to be able to finish paying their maintenance, they have, lots of boards have laxed sublet restrictions. As far as what you should consider, the normal stuff, you should still check finances. Don't get desperate. Don't just let a subtenant in just because you're hoping that someone's going to pay the maintenance, because you're stuck with a long-term problem. You can't do anything about problematic people right now effectively. So just opening the floodgates to whoever is not a good idea. But
Okay, and
go ahead, sorry.
go ahead. You were
No,
gonna.
go ahead, it's fine.
Okay, so I would also add, read your bylaws and your proprietary lease particularly carefully, because any provisions regarding the amount or percentage over your maintenance that you can charge subletters is still in effect. That I don't think buildings have relaxed.
No, they can't, because it's embodied in the actual bylaws,
Right.
proprietary leases.
Right. Okay, so now, Tina, can you share on the screen the resolution that this is a resolution that was passed unanimously by Community Board 9 in Manhattan, requesting that the City Council act to provide financial assistance for HDFCs. And that assistance would be through requiring the Department of Finance, Department of Environmental Protection, and HPD to renegotiate payment agreements and reduce interest rates, and also provide for property tax forgiveness or reduction, given the fact that there is no other assistance directly provided to HDFCs during this pandemic, where tenants are receiving assistance, landlords also, and receiving forgiveness, but HDFCs are not. And so, Tina, are you sharing it on the screen?
The host needs to allow me to
Okay.
screen share.
Okay, I think I did.
Okay, let's try that now.
It works.
Try it again. Okay.
I think Michael might have to do that.
I think Utah needs to.
Okay, well, anyway, while we're negotiating that, so the resolution calls on the City Council to immediately enact legislation to require the agencies that I just spoke of, the Department of Finance, Department of Environmental Protection, and HPD, to renegotiate payment agreements with HDFCs that are suffering directly because of COVID. And a question was also asked, what about the facade inspection safety program? Is the Department of Buildings providing for delay in those inspections and not leveling fines against buildings that are unable to, for financial reasons, to not comply with the FISP? Emma, do you have the answer to that question?
I don't know of any exceptions to compliance that have been in place. It'd be nice if they passed something, but I don't know of any forgiveness for the lack of compliance. Now, whether or not they're actually effectively doing it, I don't know. That might not be happening, but an actual regulation that says that you don't have to comply, I'm not aware of.
Okay, so well, we can check that with the Department of Buildings and see if there is any forgiveness. And I do know that the Council of New York Cooperatives was working on this, but
Yeah.
we can check on it and post it in on the website. I'm sorry.
I can tell you that I've had a couple of buildings that were listed as hazardous, and they were required to move forward with their facade projects because they were listed as hazardous. So there was no letting up, let's call it, at least not from that perspective. That's not to say that there's not something new coming down the pipeline. If there is, I'm not aware of it.
Okay, I'm just looking through the list of questions. So what we'll do is, it appears that we're having some trouble sharing something on the screen. So we will post this resolution also in the chat. And if there are any additional questions, we'll give a couple minutes for people to.
Tina, try it again. All panelists are approved to share the screen. I just double checked it. You should be able to share your screen. I'm not hearing you.
Yeah, I'll try it again. I mean, that's the warning that I got, but let's see. I'll work on this. Well, you guys keep on moving ahead. Don't wait
Okay.
for me.
So
Yeah, can we go to the next set of questions?
yeah, I'm doing that. So there's someone saying they have a clear procedure buying in. A shareholder collects higher sublet rents. I think that this question is just speaking about an errant shareholder, and the normal procedure to begin holdover proceedings would be applicable in that case. The fact that there's a moratorium on evictions, it doesn't mean that you are not still able to file a lawsuit against a shareholder who is not following the rules. It would just mean that you're not able to pursue eviction until the moratorium has been lifted.
But I'm going to tell you, April, practically speaking, the courts have adjourned every single case into March. So I was conducting conferences on holdover cases, resolving some of them. I had trial dates coming up where they were going to do virtual trials, some in person, and they've adjourned every single one to March. They won't even do a conference at this point.
Okay, so they've adjourned them, but it's still on the record that the
Yes.
case has been filed. That's
Yes.
what I'm getting at. So if there is a shareholder who is not following the rules and you decide you want to pursue a lawsuit, you can file your lawsuit. There will likely be no action on it.
Correct.
For quite a while, but it doesn't preclude you from filing. And yeah, many of the questions deal with the financials and financial resources that are, as we've stated a number of times, are not really available for HDFC. So what we are pushing for is for legislation by the City Council to be introduced requiring that the applicable agencies renegotiate agreements with buildings that have outstanding payment agreements, and with buildings that are unable to pay their taxes or their water and sewer charges, to not incur the penalties associated with that, and have negotiations with the applicable agency to structure a payment agreement in those instances. And we would encourage everyone to, as I said, we'll post this on the website, and we would encourage everyone to contact their council members to support this proposed legislation. And we are asking that Mark Levine, who is the council member in Community Board 9, or the majority of Community Board 9, and the Speaker of the Council, Corey Johnson, to lead the charge in getting this passed on behalf of HDFCs. And we're requesting it at the city level because HDFC cooperatives are not entirely, but mostly a New York City entity. And so state law, which could potentially govern this, because the agencies are city and mayoral agency or request agencies, we're requesting that it be done on the city level.
April, I'm posting a link in the chat.
Mhm.
I don't know if there's a better place for me to do it, but to the SBA page where they address the second PPP program, and they give you information about it and how to go about qualifying and calculating what you should borrow.
Okay, so please refer to the chat. And I'm just looking to see, there are a couple of other questions. Let me just get to
It actually gives you a link to locate a lender. Talks about once you get a lender on the phone, they literally walk you through the process. You just have to have your financials ready in order to know what your math is.
So the website is hdfccoalition.org, and we'll put that also in the chat, and the resources will be linked on the HDFC Coalition website, hdfccoalition.org. And another question, are tenants allowed to have Airbnb in their HDFCs? No.
Just know.
Short-term sublets are not allowed. That would be a violation of your proprietary lease.
And Airbnb, anything under 30 days is a violation of New York City law. So
Yeah, so Gloria is posting in the chat that there's a maximum of 10 years for repayment agreements, and we're asking for a total restructure of that, so that if it's necessary, building by building, to do a longer period than 10 years for the building to remain affordable, that would be a part of the legislation. And we're also stating that this assistance should not come with the requirement that the building sign a regulatory agreement. Our position is that in times of crisis, HPD or whatever the supervisory agency, which would be HPD, should not use that opportunity to require draconian measures be put in place in exchange for assistance that buildings need. I think that we have gotten through all of the issues, if not most. So Michael, do you want to do the closeout?
Yes, and I want to thank Emma for a wonderful, wonderful seminar. Very, very informative, very interesting. I learned many new things. And again, I would like everyone that if you have further questions or want to link to the resources that we spoke of today, including the PPP, you can get that on our website at www.hdfccoalition.org. We will also post on the website the information, extra information, and we'll try to put it on the same sheet that Emma mentioned tonight, the links that she shared with us, as well as dates of our future webinars for candidates nights or forums with our next set of those who are aspiring to hold elected office in areas where there are high concentrations of HDFCs. The coalition itself will sponsor these webinar and candidate forums, but we are also organizing HDFCs in their neck of the woods for Brooklyn, South Bronx, other areas of Manhattan, Chelsea, and the Lower East Side. Hello, Harvey Epstein. And the Lower East Side, so that local candidates can attend local webinars and speak to the interests and concerns of local HDFC shareholders in those areas. The coalition itself will be handling a much broader election runs for office. For example, I believe our next one, January 27th, will be for comptroller, citywide elections, I should say. And the one after that will be for public advocate. But we will have a more detailed list of those citywide offices, and hopefully the candidates running for those offices will attend again HDFC shareholders and their household represent more than 80,000 registered voters throughout the city. And so I think it's going to behoove them, and it's going to behoove HDFC shareholders to see where the candidate stands on important issues concerning HDFCs. Again, I want to thank April and Emma. Want to thank our interpreter, Hannah.
Also,
And the other attending panelists, Tina. I'm sorry, did someone want to say something?
Yeah, so
yeah,
let me kind of.
I'm sorry, I just wanted to jump in and ask Emma at some point to give her contact
It's in the
information.
chat. She's put
I
it.
just put my email address in the chat for
Or
everyone.
Yeah.
Okay.
Yes,
chat.
yes, and we made a presentation at the beginning as well.
So Michael, I just wanted to thank, I noticed that Eric Coelho from Councilmember Levine's office was here, and Erica Rodriguez from Assembly Member, Congress Member Adriano Espaillat is also in attendance, and additionally, the chair of the board of the West Harlem Development Corporation, Milton Tinkling, is also in attendance. So we welcome you and thank you for attending. Hopefully you got more information about HDFCs and will help us in our advocacy efforts.
Fantastic. I also want to
April,
take this chance
April,
to thank
April.
Yusa, who's going to speak right now and say something very important.
Oh, you're welcome. April, I just wanted to make a correction. Erica Rodriguez is from Assemblyman Taylor's office.
I'm sorry. I promoted him and you.
And I also want to, lastly, but certainly not leastly, thank Signe Mortensen, who is our wonderful Zoom coordinator, helps us get us all coordinated for our meetings, set up the interpreter, and make sure that everything sort of runs smooth on a technical basis. So with that said, I would like to thank everybody for attending tonight's webinar. Please go to our website, watch our Facebook page for upcoming webinars. They're going to be fascinating and important for us, not only to get to know the candidates running for office, but to understand their positions and perhaps have an opportunity to educate them on HDFC concerns and issues. So again, with that, April, do you want to have the last parting shot?
Last word, this webinar was recorded and it will be available on both the Community Board 9 Manhattan's website, as well as the HDFC Coalition's website. And it should be available tomorrow. So you can check back and you can hear the whole thing again if you like.
Wonderful. Fantastic. Well, with that said, good night, everybody, and thank you. And we'll see you next time, January 27th, for our Comptroller Candidates Nights Forum. Thank you and good night.
Great.
I thank
Good
you.
night. Awesome.
Michael, don't close. Don't leave. Don't shut the meeting down yet.
Okay.